Hi, people. How is everyone? Lots of ground to cover. I don't know if anybody saw on Andrea, but Andrea is fixing to rant, and I'm like, bring it. Got a lot to talk about. Want to cover, obviously, bad judges, Delphi, Canton. Then want to talk a little bit about some interesting stuff out of Arkansas that smells a whole lot like trying a case in the dark / gag order / shades of holy shit. So I'm just going to bring Andrea on and woo.
Hello.
Hi.
Hey everybody.
So backstage you said I could rant for hours, and I'm like, go ahead.
Good. Are you ready to hand it over? Shall I just start?
Yeah, just go ahead.
Well, I will tell you, I want to give you credit because what actually got me in the ranting mood was listening to your interview with Andy Baldwin.
Ooh, go on.
Yeah, well, I had, of course, I lived and breathed Delphi, extensively for quite some time. But it's just, sometimes the soup has to simmer a little bit before, the full flavor really develops. And I just had a moment of just increased outrage at the safekeeping hearing, and then the ambush, particularly the ambush. And what was so frustrating to me was just remembering how there had been this, sort of campaign to suggest that all these steps towards greater transparency were being taken in Indiana that Gull was a part of, this new rule that was going to allow cameras in the courtroom and so forth. Meanwhile, behind the stage, they were changing the rules of trial practice to make it so that the audio recording is no longer generally available to the public. It's only available to the attorneys on request. Of course, making, no big sign about that at all. So kind of giving let them eat cake if we feel like it, sort of handout on the one side while, taking away rights with the other hand. But then just the manipulation of that process and the use of the media as a threat, to just the blackmail almost, kind of manipulation of that media resource. It really enraged me, particularly in the context where we are right now, where it is still, how many months are we at now past trial? Are we at 8 months, I think, since the verdict? And still, this game that has been played with exhibits in particular. It took a clerk of the court with a conscience and an interest in the public to get the transcripts out. So now that at least is available for people to be able to read. But just the complete and total contempt that this court has demonstrated for the public's interest in this case. And it's so particularly offensive because it's, I've been saying this for a long time. This is the interest that they cultivated to try to get people to pay attention, to provide tips, to give information, to help them try to solve the case. And then as soon as they get a lead, it's just an absolute slap in the face with the, the bloodlust and then everything that we've seen unfold. So you really got me fired up about this issue now with manipulating the public's access to the courts, and how that's really reflecting a trend that I think is so alarming, which is the courts trying to manipulate a public narrative of a case, which is just like so counterintuitive to what the process is supposed to look like and the function of a free press in the courtroom is supposed to be.
Yeah. So all of yes, and I'll allow it.
That, Angie, you got my blood pressure up.
I'll allow it, Andrea. I'll allow it. I think that was, I for one was glad to see some Baldwin outrage. I mean, honestly, I know that there's a lot going on there, but I'm going to reference Attorney Alessi, who was talking to Bob and Ali Mata last night, and I just caught up on it today, but he made mention of this sort of lack of access to justice. And you and I had talked about how this is very much a part, including all the money that and having a good defense, but even access to information is now it's commodified. And I think the thing that you touched on, that when I found out y'all had to do some fundraising for transcripts, I'm like, absolutely not. No, I say nay. And so because it's asinine. And I would use the example of a brutal murder case that I was reporting on in my home state of Iowa. I literally called up the clerk. I got everything. I got stuff I did not even want to see. But that's because they're just like, yep, all right. And I'm like, okay, so when can I get that? She's like, oh, you should be in your inbox. And I'm like, all right. I have never seen what happened in Delphi with the way this court behaved and with the way that, to your point, this crafting of a narrative, with a first of all, with Diener being an absolute lunatic, with this framing of bloodlust. It's like, sir, can you please show me where the bloodlust is? I don't know what you're talking about. Can we have a bloodlust evidentiary hearing before you close it all down?
With the defendant present, maybe is that too much to ask?
Oh God, it's just, but it's like, you're absolutely right. So, and it was a weaponization, and you and I spoke, I don't know, earlier this year, and what you talked about with the sort of descent into Lord of the Flies to even get into a public trial. And it's, people sitting up, and I like to look at it this way. Look, it's like waiting out front of Vets Auditorium in Des Moines, Iowa for a Duran tickets. That's the only time anybody ever needs to stay out front. And I haven't done that since the 80s, for crying out loud. Nobody should be sitting out front to have to attend a public trial.
But it's routine now. But yeah, it's routine with these public trials. And part of that is, I mean, I do understand, the courtrooms have limited seating and overnight. But there are so many mechanisms now to be able to deliver the trial to the public. And that's the part of it that has become kind of difficult to swallow. As everybody knows, I had filed the extraordinary writ in the state of Indiana, trying to get among other things, I was trying to get access to the audio recordings so that people would be able to hear them, and then it doesn't matter who is available for the limited seating that they have in the courtroom. It would just take so much of the pressure off. It would just let the people see like what's wrong with sunlight. And so that, of course, was how I then discovered this little shenanigan that they had played with the rules, where just the year before Richard Allen's trial, they had gone through this rule revision process. And so one of the things they had done was change the rule so that the public is no longer entitled to request a copy of the audio recording. So this caught my attention. Once I figure this out, and of course I get the ruling denying it and everything like that. So I'm like, well, what about the First Amendment basis? Like, is there a potential way to go back and argue the First Amendment basis? So Andy, I went down this rabbit hole and found all of the bad law that there is on access to audio from
in
court.
Indiana specifically.
The one that is kind of the most prevalent out there is out of the Sixth Circuit. So it is not Indiana in particular. It was out of Michigan. But it was a case very, dealing with this very specific legal issue of somebody's trying to get access to the audio recording, and under the rules of Michigan, the public isn't allowed to them. They aren't sealed records or anything like that. But just as a matter of policy, it's not provided. And so that had been challenged by folks, and the Sixth Circuit basically said, nah, there's no history and tradition of being able to get audio recordings, and if you can get a transcript anyway, then you don't really need one. And it's not really a court record anyway. Like all of this, just like kind of smarmy double talk for why what they care about from the constitutional perspective is just the butts in the seats. And so basically the standard is if they don't lock the courthouse door, then you have access. Okay, that's kind of the presumption, and
Right.
there's a little bit of case law that's suggesting that representatives of the media, that's part of why courts can have special
Mhm.
rules for media access and things like that, because they're there to be our eyes and ears of the public, right? Well, some of us would prefer to see things for ourselves, and we do have the
Yes.
right to do that.
Yeah.
But then you can also just see how that is so easily distorted, like we saw it in Delphi, where you create the privileged class of people who get the automatic admission. You create the Lord of the Flies setting for
Mhm.
everybody else. Time and time again, we were running into concerns about, am I even going to be able to make it in? I'm trying to be thorough. I'm trying to provide this comprehensive coverage, and we don't know if it's going to be possible. And the First Amendment just doesn't really, as it's been interpreted by the courts, they just don't really seem to care.
I'm going to object to the Sixth Circuit and tell them to blow it out their ass, because the thing, look, it's an extraordinary writ. I just created it because apparently you can just do whatever you want with the people's information, right? But I find it flies in the face of do these people are these people still using teletypes, and are we still like tapping it, clicking it out on rocks and stuff because the thing is that, okay, that's great, Sixth Circuit, that's fine. You think that it's somehow precluded from public, but by definition, public trials and everything within that record, including the audio. I mean, cripes, I can listen to people argue at the Supreme Court, for crying out loud. You can listen to, so what is going on in your nebulous little weird courtroom that is so under wraps? And I think that in Indiana, and maybe it's the same thing, I don't see, screw history. What are they even talking about? I mean, what, you want precedents for this? You want precedents for audio?
I mean, this is so baffling to me, because I can't conceive of any set of founding fathers that would be like, sure, if the courts are producing this reproducible record of what is happening there as part of the legal process, they would be totally fine with denying that to the people to whom the government belongs. Like, that's that's not the founders I'm familiar with.
So I think that's like that's amendment, or actually that's I think that's in the Bill of Rights, the appendices go fuck yourself edition. because it's just, but this is a thing. It's like this is in creating that special class, which I think is important. You talk about this special class of journalists, and I gotta disabuse people. I think the court leverages that, obviously, to put the butts they want in the seats, because we know that it doesn't, you can't be an independent. Let me put it in this perspective. Even as a freelancer working years, over the last 20 years, it's harder than hell to get press credentials for some of these places if you aren't with a legacy media. Hey, knock, knock, knock. Nobody's been with legacy media for a long time. So maybe the court wants to catch up with that.
But a lot of them even specifically define it that way. Like, California law specifically defines it in terms of association with the legacy media. Indiana, you couldn't have a Substack, for example, and get credentialed. We had a journalist there who was covering it, Dave Bangert. He was from West Lafayette. He'd been a journalist with the West Lafayette local newspaper for something like 25, 30 years. I mean, a long time, had recently retired and had a Substack, and they were denying him press credentials because he didn't have it, literally defines it in terms of your relationship to a legacy organization. So he ended up having to associate with some other news provider and was able to get credentialed that way. But it's ridiculous. Not to pat myself on the back or anything like that, but frankly, a lot of us YouTubers were getting far more eyes, more coverage of the trial. But we're not the right people, so we didn't count.
Well, and I think that's why and you're right. I mean, without you, Loyally, and Bob, I mean, honestly, relaying the true, and now, I mean, I would watch, I couldn't stay up for all of your streams, but I would watch, yours. Right. No, you did great. You did great. But But the thing is, it's like, as the days progress, I'm like, surely it can't be that bad.
Mhm.
Oh, we can't be getting that message. Can we? Can this be? But now comparing, it's nice. Well, nice. It's seeing it now in the transcript as it actually played out, match
Mhm.
up so correctly with of course people are going to hear different things. People are sitting in different parts of the courtroom, blah blah blah. But you know, seeing the transcripts brings so much more to light, and that's when I really I mean, my hair's been on fire since I was born, but
Mhm.
I mean, like really on fire because
Yeah.
I've got a real problem with the way that everything rolled out in Delphi from a journalism perspective, because there was
Mhm.
no journalism. I'm
Mhm.
sorry, there just simply wasn't. There was a media narrative constructed by a few people that were handpicked
Mhm.
lapdogs
Mhm.
for the state, and the
Mhm.
state catered to that forthwith. And it's
Mhm.
like, holy cow.
Mhm.
But now you see why, right?
Yeah.
God forbid
Yeah.
the audio gets out. Because how many inaudibles, how many sidebars,
Mhm.
how many officers? I mean,
Oh,
there's even
Andy, and
officers that
just
aren't
little
named.
just little things like the tone. Like I started from the beginning, and I've seen like little bits and pieces. So I still have a long ways to go through all the transcripts and stuff. I feel like I've barely gotten started, but I've seen the little bits and pieces that other people have found and posted and things like that. And I remember somebody caught the part at the end of I think it was the last day of jury selection, or maybe it was the motions in limine the day before we went to Delphi when we were still in Allen County. And she, at the end of the court, she snapped, like she just
Yes.
just snarled at this member of the press who had been starting to get out of his seat and leave the courtroom, and she just snarled at him. And I remember this so clearly because she was looking in Mr. Rosie's direction, and I saw him like jump and freeze. It was like this, this just pure adrenaline, reptilian brain
Right.
response. Like he had been programmed, to be alert, hyper vigilant to attacks
Yes.
from the judge.
Yes.
And you don't get any of that from the
What?
transcript. You don't
So
see any of it.
we have to like really think of it. It's like Pavlov's dog, but it has to be something like Gull's something, because that's exactly what it is. They
Hmm.
were conditioned, the media was conditioned, that true, and because everyone was trained the uh from the gag order um on to be very, very trepidatious about talk. I mean,
Yeah.
I was surprised Mr. Baldwin would even talk to me. He's still skittish. I'm like, it's
Yeah.
okay, bud. Come
I
on
don't
out.
blame him at all. I mean,
Yeah,
she's trying to put their licenses on the line. Like that's really as far as you go with a lawyer. Like, yeah, there's lots of congeniality between lawyers and a little bit of boys and like pat each other on the back
right.
and things like that, backroom stuff that happens. And to the extent that is, I mean, just one of the unwritten rules is you don't go after another lawyer's livelihood. Like
Right.
that's just you need to have the goods. You need to really mean it. It needs to be justified if you're going to do something like that. So her going after them, and I mean, yeah, trying to cause them problems with the bar, problems with ethics and things like that. uh it's extremely aggressive and below the belt, and yeah, that's going to be very intimidating to them.
Well, and of course it is. And I think that, and I don't think people understand the level to which that was happening. And I think that, you know, uh, everybody likes the Monday morning quarterback, right? And I think
Mhm.
in talking with Andrew Baldwin before we went live and he was backstage, he's just, he beats himself up. I'm like, first of all, you're not going to do that here because it's okay, right? Let it
Yeah.
all hang out. Whatever. We're going to talk about, but I get why he's doing that, because I should have done this. I don't know if you noticed in my talk with him, he was speaking about, and I'm not a lawyer. I just play one when I'm running court with my cat. So
Mhm.
look, take it for what you will. But when he was saying all the eye rolls from Judge Gull, right?
Mhm.
All of these things that she was sort of almost like, did you notice that part? I don't remember. I don't know if you saw that part, but he's like all these eye rolls. He said, I wish that I would have said something at sidebar and said, you got to knock that off. And he didn't. And then, so he's playing that back in his head. And I thought that was interesting because, in Gull's order for the sentencing, she wrote, I see you're rolling your eyes at me, Mr. Allen. I'm like, I don't believe a goddamn word you say, lady. I truly do not, because anyway, but so there's things in there that they wanted to, go back, coulda, shoulda, woulda, but they really were like totally hamstrung from the
Absolutely.
beginning.
And I mean, the thing is that you're always going to do stuff like that. You're always going to revisit and second guess. I mean, that's really normal. And to me, that kind of thing, it's part of why I have so much respect for Andy Baldwin. Like, he is just the salt of the earth. He is so much integrity, so much authenticity. He just exudes, warmth and acceptance and things like that. Just a great human being. And so, yeah, I mean, seeing them treated like that, it's just, it's very appalling. I can completely understand like why they would have had that kind of startle response with her, because yeah, when you're in the moment, you're concerned about getting through this moment, and they had to legitimately concerned about how is she going to retaliate against me? How is she going to retaliate against my client? Like, you have to weigh that trade-off. And that's why for somebody like him in his position, the Monday morning quarterbacking, I think is, it's normal, but it's also just, it's not helpful, because there was a reason why you did it the way that you did it. It wasn't like it didn't occur to you or anything like that. You knew there was going to be a price to pay if you did that. And at the moment, the most important thing is doing everything you possibly can to try to get that not guilty verdict. And all of your attention and energy has to be focused on that. So if she's going to make that harder for you because you're documenting her bad behavior, that's a strategic risk you got to calculate.
Right. It's interesting because, when we think about the appellate process and where that's going and judicial bias, and I think that, the grave concerns, which is also, one of Bev's taglines. Is there, I mean, I think that there just the amount of sticks piled upon one another that form like this log of judicial bias. Like, I don't know if there's one thing or another that shows how biased she was, but man, oh man, it seems to me like, is that something appellate wise that is an actual pathway to appeal?
Not really. Not really. It's not a particularly viable one, like 99% of the time. And it's because the standards are so deferential to judges. Judges don't want to call out other judges, because then other judges might call you out, So it's all just part of the system and how it kind of perpetuates itself and doesn't correct its errors. So with something like that, the problem is that you have to have a record that shows actual bias, and that's almost impossible to accomplish. I mean, bias is defined so narrowly in the law. Like, you have to show there's a financial interest, a family interest, or just such antipathy that it would be, it'd be obvious and completely undeniable that she can't rule things fairly for the defendant. And they typically won't look at the process of a case and your history of your rulings and things like that to try to make that evaluation. They look at each individual ruling as like, well, was there any justification for it at all? And if there was, then no harm anyway.
There's no cumulative problem. There's no like cumulative.
It's so difficult. And the problem is they will give every benefit of the doubt to the judge. And so if it's a situation where, like, say you have a record where it looks like there's maybe a lot of conflict between the judge and the defense attorney. I've read transcripts like this, and they're snappy with each other, and there's clearly like no love lost or anything like that. it's not going to matter. The courts are going to be just as inclined to think, well, the problem is the defense lawyer, as they are going to think, the problem is the judge. So they will bend over backwards to try to justify stuff like that. And I think part of the problem is because, again, they're concerned about that lens being turned around on themselves, and like, oh, what if I have a bad day, and then then I'm being publicly embarrassed because my name is in an opinion somewhere. They don't want that. So they pay it forward. They do the favor to that trial court, and that's how the whole system gets perpetuated.
Well, I can't wait to talk to you after you get to the part in the pretrial hearings where Judge Gull is bragging about how quickly she prosecuted all of these death penalty cases.
Mm-hmm.
Yeah. Also, side note, she has been, she's had her name in plenty of appeal rulings. Now, one of them was it was a chef's kiss for me with Judge Gull. It was a death penalty case, I believe, and she threw in some crappy ass commentary, like Hitler-esque commentary at the end, and they were like, and it was essentially like the rolling your eyes. It may have actually been the rolling your eyes thing, and they were like, okay. All right, so we're gonna go ahead and kill this guy for you, Fran, but we're gonna need you to rewrite this last part to make it look above board.
Isn't that always fun? Yes.
I'm like,
go back and revise your findings. Make sure you make this finding. Okay.
But anyway, yeah. So
yeah.
So it's just, but so you went through. There were so many different solutions to the open another courtroom, have some, even like speakers outside of in another area for people to sit, overflow room.
Not put trash bags over your Zoom camera court system, like maybe you could just not do that. And literally like trash bags wrapped around the cameras they already have there in that courtroom. They were so paranoid about a slip that they and these courtroom ceilings, Andy, these are like probably 18, 20 feet high. This is like an old high ceiling courthouse. Somebody had to get in there on a ladder and do this, went to a lot of trouble to make sure that eyes would not be on that courtroom.
It's like, this is my speculation, but I'm going to say that Nick did that. Mm-hmm. I'm going to say that Nick got on a ladder. No, because Fran called him at home on a weekend and said, "Hey, bud, look, why don't you file that motion in limine about the third party?" Wink, wink, and then go scoot your little buns in, go to the Walmart, get the cheapest garbage bags you can buy, because I'm not going to refund, I'm not going to give you money for it, but get in there. Mm-hmm. Anyway, that was my speculation. Just it's asinine. But so when looking at that and the way that it happened, and we're laughing, but it's like a man is now been renditioned yet again to what was the worst prison, or is the worst prison in Oklahoma. Richard Allen has now been, renditioned essentially to this prison, and what is that going to do for it's kind of like when he ended up in Westville. You got to kind of get him out of the and there's not, meaning that we're laughing our heads off, but everybody knows that we're laughing because otherwise we'd stab ourselves in the head because it's just so awful. It's just
bashing our heads against the wall. Yeah, it is.
All of it. But when we talk about the comparison, and when I was talking to Mr. Baldwin, and I told you this before too, is the Karen Reed crowd kind of started dipping their toe into the Delphi arena. I don't know if they are or not, but when I said to Mr. Baldwin, this is not a great analog, but to help people understand the absolute nothing case that they had against Mr. Allen, it's like mere presence, right? 34 Fairview, the High Bridge. Then you've got Magic Bullet, and you've got Magic Glass, and then you have I hit him, I hit him, I hit him. I shot him in the back. I might have done it. Oh, by the way, I've been tortured for months.
We have the failure to ask the obvious questions. Why didn't you go in the house? Whose DNA is that all over and inside the girls?
Anyone? I mean, it's just, at least we got to see sort of what was happening in the Karen Reed. I mean, at least we got to have eyes on it as a public, but you know, and even then,
but I will qualify that because of course the sidebar was a common like recurring grievance that I had throughout the course of you know, both this trial and the first time when they tried it, because the sidebar is supposed to be for a very limited purpose. It's to be able to have brief arguments about issues that the jury can't hear. And so, you know, there's an objection. It's not, you know, completely clear what the basis is. They just need a clarification maybe of what your thought process is in order to be able to make that ruling. That is what the sidebar is for. The sidebar is not a way to conduct major portions of the court business outside the view of the entire public. In fact, it's very, very common and routine with a sidebar. Say, for example, you know, we've got this evidentiary dispute. We call a sidebar. It's clear it's going to become a little bit more of an in-depth issue. We excuse the jury from the courtroom, and then we go on the record and we have our argument. Like that's normal. And so the sidebar is just supposed to be for the quick thing, so you're not taking the jury in and out all of the time. But Bev was using this as a way to vet all of these issues and talk about things that, for whatever reason, we, the public, you know, weren't entitled to hear. So as far as I know, that all of the sidebars from the first trial are still impounded. The second ones have been impounded, but I saw that she did just, I think yesterday, file a motion. Karen Reed's team filed a motion for those sidebars to be released, which they absolutely should. There's no justification at all for them to be withheld from public view. The sole justification that was ever given, there were basically two grounds: the privacy of jurors and the confidentiality of the federal grand jury materials. That was one basis. And then the other was just a fair trial. And so the trial has been done. She has had her fair trial. That is no longer a continuing justification. And these other things, to the extent they're discussed in the sidebars, that can be solved by redaction. So there's no justification. The First Amendment says we are entitled to this. This is the record of the public process. So it's just insane to me that she has to be paying a legal team to be going into court to make this argument. And bless her, by the way, for doing that, for the benefit of we, the public, to be able to get that full transparency and, you know, get more of the flavor of the rulings and the interactions between the parties and those kinds of issues that I think so many of us were concerned about Bev's concerns.
Oh my God, please give me, I have grave concerns in your best Bev voice towards Mr. Jackson. I know I'm putting you on the spot.
Well, she was like, I mean, I can't even do it. She was so like worked up. She's doing that heavy breathing and everything.
Yes, it was like,
I don't think I can do it. And that's caused me grave concerns. It was like, you know, the Darth breathing.
You know, I mean, and the thing is that, and this is why it was like bad judging, right? And we saw that, and it turned out to be, you know, Hank, a motion to withdraw. And yes, I will, like your mom should have. I'm sorry. Sorry, I had to. Gross. But I mean, then you had him just lobbing absolute bullshit. And she just took it as fact. And that's what Nick McClelland did. From everything that I could see, this is what Nick McClelland was doing. He was literally getting up there and saying, trust me, Fran, you know, trust me. wink. I mean, it's almost like they were having
Yeah.
some sort of telepathic conversation or ex parte,
Well, the message I
communication.
think was simply clear. Like, I don't know that they even needed to get to that point because look, if we're on the same side, it's kind of like you're saying, we can just, like I get it. I get what you're trying to do. And if you've given me some justification, it might be a bad justification, but it's one I can use. And so, hey, you want to trip up the defense lawyer and say that this is improper impeachment? It's not, but you say it is. And so it gives me a basis to give you what you want. And that was kind of the hidden message that I was seeing so much behind all of it, because so many of those types of decisions were just so ridiculous. I mean, I'm pretty sure I remember Nick McClelland talking about like 3 or 4 different ways you're supposed to do impeachment. It's like, no, that's not the rules. Here's the rules. Very straightforward. Here's like a publication from the Indiana School of Law, talks about how to lay the foundation and so forth. I mean, it was a facade. It was all that they were really aiming for.
Well, in the way that, so, we start but I think that my thing about helping people, because it's hard to talk, or it's hard for some people to talk about a crime where 2 13-year-old girls are murdered versus a Boston cop is murdered. Pick your whoever, right? Mm-hmm. It's hard for people to talk about that from a place of confidence or, out of respect for the victims. And, I try not to get past get into the victim of it all and focus, at least for my purposes in Delphi and some of these other situations, this is about the actual process and what the trial is for. And the trial is actually for the defendant. And I know people hate that for some reason, but is it not? Am I wrong? I mean, it's about justice, but isn't it?
I think that people often have this kind of one track view of things where it's like, oh, if somebody, commits an egregious crime like this, it's because they want attention. And so then therefore, talking about the trial, saying their names, things like that, it gives them attention. And the problem with that is it seems extremely inaccurate to me. Like a lot of the time, the Koberger case that we just got resolved, I think is such a great example of that. I've seen so many of these, assertions. Oh, he wants attention and it would be giving him the notoriety that he seeks and stuff like that. The guy said like 10 words throughout the entire case. Like he had all kinds of opportunity to speak up in court, never did. The whole theory of like why he would even want attention doesn't make sense to me. Like, okay, you're trying to tell me that like he committed this crime because he wants to be a criminal mastermind, but then he grievously failed. And so somehow you think he would want that to be like front and center and getting attention for the fact that he didn't pull it off. Like it's not a very cohesive theory. And I think it's just a mental shortcut that a lot of people take. My approach has always been, because one of the people that I sympathize with, most in the courtroom, I sympathize so much with Kathy, with his daughter, with Rick's daughter, his parents, the family of, I mean, certainly an innocent man like him who didn't even, do what he's accused of doing, but the family of a perpetrator as well, are often suffering extreme loss. Right. This child that they had all of these hopes and dreams for, it's come crashing down, and it's just a type of suffering that it doesn't get a lot of sympathy. And that's, I think some people just feel like if I am anything but 100% focused on the victims, that it's somehow taking something away from them to have empathy for others in the process. And it's just, to me, such a narrow and limited way of thinking.
Well, it actually is, but that's part of the white hat, black hat disease, right?
Yeah,
that one cannot be, empathetic towards the family, look,
yeah.
I don't know what I would do.
There's some blood attainder in there somewhere too, I think.
It's like, well, yeah, exactly. It's like, exactly. So it's like, but so it's just like, and I think that it's almost like I mean, it's almost like a grief response or something for certain people. Like, oh, it's like a weird sort of denial of humanity of I mean, look, if it's whether it's in any case for the defendant, to have some sense of humanity, throughout the course of, certainly through his arrest and pretrial and Mr. Allen or whoever, but that to maintain that humanity and not immediately, do all of this splashy headlines that give absolutely no context and just really are about painting a picture because that's what we've been sold. And I do believe that. It's like, good guys here, bad guys there. It's like, it's really a lot more nuanced than that, America. It really is.
It always is. And I think too, it reflects a real fundamental misconception of what the criminal justice system is and what it's for. Because I've said many, many times, Andy, we have the criminal justice system not to protect us from criminals, but to protect criminals from us. It is not a private justice system. Okay. If we had a private justice system where the just getting vindication or whatever for the victim is all that we care about, it would quite a lot different, than the system that we have. You would have much more of a Hatfield and McCoy, type of process going on. It would look more like private prosecutions and stuff like that. But we don't have that because the crime is considered not just a crime against this victim, but a crime against all of us, a crime against our society, a crime against the rules and the respect that we have for one another and that we expect everybody else to step up to and to live according to this agreed standard. And when you don't do that, you are breaching the social contract. That is why we as a people fund a government system where prosecutions are done in our names, because it is a crime against us as society. So no, it isn't just about the victims. I mean, certainly their pain matters, and nobody would deny that. And
No.
It's very much a consideration that comes in, certainly in the sentencing process of a case. But that's not the focus of what the process is for. And the reality is that the criminal justice system is never going to make anybody whole. It can't do that. Once the crime has happened, justice is already gone. And what we are providing is kind of a poor substitute, a way to try to transform it into a positive by giving closure, by giving condemnation, sometimes by, providing rehabilitation. But the wants and desires of the victims they matter, but they aren't the driving consideration at all.
Right. And I think that, it's not really the criminal justice system, right? It's a criminal legal system, and that's what it is. And I think that's a more accurate way to talk about it, because it is not because I think justice is something that is aspirational.
Yes,
right?
100%.
That's an aspiration. There is no justice that's ever going to bring back your X, Y, and Z or replace your, whatever that has been lost. So the idea that to throw it around, the way people are like, we got justice for the girls. Okay. First of all, true justice would be this never having happened. And we would all go back in time and everything would be great. But in the meantime, now we have this other catastrophe ongoing with trying to get the state of Indiana to cough up all of the information that is needed to show cause for either, outright overturning, I know that Michael Osbrook is a big fan of the chronic claim. I am too, because I'm like, yep, that'd be great. But at the very least, this man did not get how about a fair trial? How about investigating the crime? How about, oh my God, did you see that PCA, by the way, and the PCA for the arrest thing? Did you take I re-looked at these things, and they're basically, and this is the Richard Allen case again too. First of all, I've never seen such a piece of trash writing. I'm offended as a writer. Number one, get your poop
Yeah.
in a pile. These are legal
Yeah.
filings. You're in a court of
I
law,
know.
sir.
But you saw that safekeeping order, Andy. You can see where the bar is at, what a freaking judge signed as a legal compulsion on people is wild.
I mean, my God, and that guy, oh, Jesus wept. But it's like, but it's, I went back and rewatched, well, whatever. I can't. It's like, oh, it makes me, because I've started going back and rewatching like the first interview with Mr. Allen. And I'm like, holy crap, he told them that he was driving the silver Ford 500. He didn't say he was driving the black car. Well, wait a minute. He didn't say a blue Carhartt. You know,
right.
so,
Absolutely right. He didn't even say boots. He didn't even say boots. He said he's probably wearing tennis shoes. Like all of this stuff that they put in his mouth, and it's completely untrue. You can watch, like the video is there. You can watch it for yourselves. And I sat there in the courtroom and watched them gaslight me to my face and tell me, you know, Mullen is up there on the stand telling me all of these things that Richard Allen said in this interview that he did not, in fact, say, as I can see for myself with my own eyes. It's wild.
I mean, but the thing is that, you know, and all of that made its way into the application for the warrant. And it's the one thing that's really interesting. Well, there's a lot of things that are interesting in that first interview is that if you listen all the way to the end, when Mr. Allen is gone, when everybody's gone, the very end, you hear somebody, whether it's Mullins or Liggett, say, and they're just outside the door and you can't see anybody. And you hear him say, he was wearing the same clothes. And I'm like, sir, I mean, what are you doing? Are you looking for someone to co-sign your bullshit? Because clearly you are, you know, and then I'm like, and that just made my blood boil because I'm like, were you two just not in the same room? Of course you were, because this is what you wanted to happen. Because the thing is that I was driving the silver car. That is not my, you want me to say that's my car? That's not me. We've all been looking. I mean, he was basically
that's not where I parked.
That's yes.
That's not the direction I drove. Like
right. All of it.
All of it.
but so what happens though when it's just like, how did this even get, I mean, we know how it did. We know how it got where it got because all of this bullshit was sealed. Everything was sealed, gag order, everything was clamped down on, and no light was allowed in. The only narrative out was that we got him. We got him.
And don't look at how, and don't look at what we're doing in the meantime. Just, you know, just take our word and show up once we have a guilty verdict for you. Like that's pretty much the attitude that they had.
How often, I wanted to ask you this about the sequestration in that case. And then I want to talk a little bit about what I see has happened in Arkansas, because I sent you a copy of that. Yes. And it smells a whole lot like what went on in Indiana with the,
Indeed it does.
With
Indeed
the,
it does. And we'll talk about why.
I mean, we'll get to the trial by combat and cutting off people's ears in the Star Chamber, which I thought was like, here, judge. but with the sequestration, is why did that happen? Do you have any idea why on earth they sequestered the Delphi jurors? Because I have a speculation.
I mean, you know, I know the ostensible reason. The ostensible reason was because it was just such a high profile case and there was going to be so much media that it just wasn't going to be feasible, you know, for them to not be exposed to it in one format or another. That said, I mean, sequestration is extremely rare
Yeah.
now. It's available, but pretty much almost, you know, it almost never happens, in part because people recognize, you know, obviously you know, it's a major disruption to your life to go through something like that. But also it's just kind of the nature of the world that we're in now. And there's sort of a low, what am I looking for? Like a high tolerance for the idea that jurors don't have to be untouched by stuff. They just have to be impartial. Like, you're not disqualified from being a juror if you've heard about a case, or even followed a case, or frankly even formed an opinion about the
Yes.
case.
Yeah.
You know, so they have this very kind of cavalier attitude about that type of thing anyway. So to see it, just such extreme measures be taken to try to solve, you know, that sort of concern, it's unusual in this day and age. That's really all I can say.
Well, I thought I was talking the other day about a friend of mine in Minneapolis who was on it was a murder trial, and they were sequestered. And again, but they were only, it was like 3 days or something, you know, it was it was pretty cut and dry, but yet they took their job incredibly seriously. And, you know, the bailiffs were incredibly professional, not having big old barbecues and taking people's phones for no reason because they're following the jury. It's almost like they were fomenting an atmosphere.
Yeah.
I don't know. Look, again, this is all simply, where is it? Speculation. But it's like, but looking, you know, it's because I don't see any reason why. I can't imagine. They got to see family on the weekends. They got to have their they got to talk about the case as long as they were all together. I'm like, what? I mean, you're going to get together in the hotel lobby.
Yeah.
Because you're bored and chat about the case.
That was like the weirdest thing I think I had ever seen, was this Indiana rule. And I remember I went down a little bit of a rabbit hole at one point during the trial. And I think I talked about it on stream because they did. So Indiana apparently at one point went through this modernization of their jury rules and their jury procedures and stuff like that. And you know, so you talk about irony. Now we're still doing the sequestration, drive them away on a bus to a hotel, you know, kind of situation. But yeah, this whole rule was part of that. This idea that, well, it's sort of a fiction that you know, people need to stay completely just cut off from processing the information, and maybe it would be more helpful to them if they can kind of deal with things as they come up. And of course, the counterpoint to that is, well, you start fixing your opinion much earlier in the process, which is not what the jury is supposed to be doing. You're supposed to be taking in all of the evidence, and then, you know, once you have it all, okay, go in and start the processing and forming the judgment. But if you're starting that on like day 3, where we've just gotten the prosecution's case and we just have weeks more of the prosecution's case to come, and you're already starting to be like, well, I don't, you know, believe this person, and I think this narrative is correct. Now you're starting to look at the rest of the evidence through those biased eyes. You're going to start to select for what you see and what you pay attention to and what you put in your notes and how you interpret things, and all of that. So, but yeah, that was the whole idea behind it. Was in Indiana thought that would modernize the jury process.
Well, you know, when I think about modern, I think Indiana. So
bless them.
Sorry, I'm from Iowa. It's okay. It's like,
I really do. Amazing people that I got to meet there in Indiana.
Look, I get it. I'm from the Midwest. Like, I got it. But this is, but it's just, I can't. I just don't know why that's a good idea. But whatever. Yeah. So I wanted to talk about Arkansas. I know people, and I didn't know about this case, and the Aaron Spencer case. And I think the broad sort of contours are that Mr. Spencer, his daughter was she was assaulted sexually assaulted 13 years old or something like that, repeatedly by this man. This man was, I can't remember his name, Michael
Bossler.
Fossler, yes, was arrested, given bail, out on bail, came back, basically kidnapped the girl, you know, the 13-year-old daughter, and took her away. They realized it. The father got in his car, truck, whatever. He ended up getting his daughter back and shooting and killing the man that took her. And that's the real broad contours. And you know, I can't say that I wouldn't, you know, do the same thing if I were in a situation. But I don't know enough about anything going on. What I do know is that I was very, very interested in let me see, in the gag order that was issued. Let me see here. Because I have a couple of gag orders as the case happens. Actually, I'll just pull up the ruling from the Supreme Court it's Arkansas Supreme Court.
It's an extremely broad order, like shockingly broad.
Wait,
go right ahead.
The gag order, you mean, or no?
Yes. What the judge said couldn't be done. Who it applied to, all of those details.
Yeah. Hang on a second. It was like everybody and their monkey's uncle.
Yes.
Essentially. But what I found fascinating, let me make sure is this it? Yeah.
Yes.
So this is like, I mean, this is but this might give an overview of the case.
It does.
Okay. So let's do this. Can we make us small? Oh, we're all learning together. Isn't that nice? Wait a second. I don't know. All right. So basically this, back when the arrest took place, he was charged with a felony. The state, last year on December 4th, filed for a motion for a gag order alleging that Spencer, does this sound familiar? I want everybody to put their listening ears on because it feels pretty similar to something I've heard about. State filed a motion for a gag order alleging that Spencer's arrest had garnered media coverage throughout the state and the nation. Attached to the motion was a press release from Spencer's attorney, Aaron Casanelli, and Michael Kaiser, criticizing the decision to charge Spencer criminally as targeting a heroic father. The state also pointed to a television interview in which defense counsel allegedly stated that they felt confident that the community would support Spencer because every one of them would have done the same thing for their child or neighbor's child. So that happened pretty much. I mean, he was arrested in the end of November. Then immediately the gag order request came down and was basically just like, yep, you bet. The state argued the gag order was necessary. That, let's see, 8 content-based limitations on the speech of any party. Is this the broadness of it all?
Yeah, this is the everybody who it applies to before you even get to everything that they can't say.
I mean, so again, when you think about Delphi, and it's almost like exactly like what happened at Delphi. Exactly like what happened, down to the press release. Down to the press release. This is Judge Gull, right? So I don't know if you guys can see that, but sorry, I've got to make us tiny. Where, you know, she talks about she grants the order for the gag order, and she uses press release on the courts. I can't see it in the courts, blah, blah, blah. Yeah. So basically the justification is the same, right?
Yeah.
So Oh, there's a
Defendants
press
dare
release.
to speak up for themselves, to defend themselves against an accusation that the state has been litigating in the press up to the point of it, ending up filed in court. And
I
they're the
mean,
problem. Defense is the problem.
right? So it's insane to me that how similar these two things were. But hang on a second, I'm going to try to do that and then this. So why don't you? What struck you? So again, so this actually happened. Sorry, I'm all over the place. So this hearing was brought, or I'm sorry, this case was brought before the Supreme Court by Mr. Spencer's attorney on his behalf to I don't know, dismiss the gag order, I guess, because the district or the circuit court had ruled this bananas thing that basically said nobody could talk to anybody. Back in April, and they issued an order basically saying, holy crap, what have you done with this ridiculous order, circuit court? Absolutely not. This is bananas. And it took another month for the gag order to actually go away. I think I'm remembering that correctly.
Yeah.
There was one part of the oral argument that I wanted to play that I thought was very interesting, because the justices bring up something very early in Mr. Spencer's lawyer's argument that I think really speaks to the sort of nature of what this is actually about. Let me see. I can't make this any bigger. Can I? Ooh. Now we're huge. Okay. So I'm going to play a little bit of this. People, please let me know. And I'm not going to play a lot of it, but I want people to hear a little bit.
CR 2566, Karen Spencer.
You hear it?
versus State of Arkansas from Roanoke County Circuit Court. And I acknowledge the petitioner's attorney to come forward. Ms. Cannone. And you've reserved 10 minutes for rebuttal.
Yes, Your Honor.
You may proceed.
Thank you. May it please the court, counsel. I'm Erin Casanelli, and I, along with Michael Kaiser, represent Aaron Spencer, who's the petitioner before this court and the defendant in the court below. We are here today on a gag order imposed at the inception of a criminal case in the circuit court. Gag orders should be a last resort, not a first impulse in any case. And I would submit to you that's fairly settled law. The law requires a careful analysis and a balancing of important constitutional interests when imposing a gag order. The law requires further a very narrowly tailored order that is specific to the case, the interests in the case, and the interests of the public in receiving speech and the parties in providing speech. This court, federal courts, the criminal justice system does not favor justice in the dark. And that is what is happening in Lonoke County. In this particular case, this gag order is very important. This is an unusual case. I don't know how much factual information has been conveyed to this court, but it's unusual in several respects. Aaron Spencer is a father and a husband. His daughter was sexually assaulted severely by a man named Michael Fossler. Michael Fossler was arrested and charged with over 40 criminal offenses relating to his behavior against Mr. Spencer's child. He was released by the Circuit Court of Lonoke County with very little restriction.
So counsel, if I can interrupt you right there, just a factual clarification. Was it the same judge who issued the gag order was the judge in that case?
Yes, sir. And thank you for that question. You caught exactly where I was going. It was the same circuit court and the same prosecutor who participated in Michael Fossler's criminal proceeding.
Yeah, the one who set bail
respects.
Doesn't want people looking real closely at the consequences.
Mhm.
That I can find before the circuit court. There's no record of what bond the state sought, why the court imposed such a low bond, why there were no restrictions or supervision as to
No
his conduct.
filings,
And
nothing.
of course, that
It's
led
weird.
to him taking Aaron Spencer's daughter in the middle of the night to continue to rape her.
Counsel, I have a question that we live stream.
Okay, this is the part that struck me as really interesting. I mean, it's all interesting.
Our court proceedings, and this is a public hearing. So, and it's live streamed. It's also saved on our website. Is that violating the current gag order?
That is an excellent question, and also on my list of things to discuss before this court. This gag order
Great
is so
question.
broad that I don't know that I can answer that question precisely.
I mean,
Yes. Yes, it does. It does. If you read the plain language of the order, some of them talk about statements, statements for public dissemination. I mean, if you're saying it in a public court proceeding, that's going to count. Some of them just say make any statement at all. Like it's so extremely broad.
let me see. It's just so beyond. I got to that point and I'm like, the justices just should have stood up, said, nope, no gag order, and walked out. Because it's,
And you asked me kind of at the beginning, like what about this is kind of most shocking to me. It's the legal ignorance of the judge that signed this in the first place, because it's one of the first things the attorney led with. This is like pretty much black letter law, and it is. You know, I'm mostly familiar with the Gentile case because that's what comes up most commonly, Gentile versus Nevada, and that's a case that dealt with attorneys making statements to the press about pending cases and the extent to which ethics rules can be imposed on attorneys, and this is recognizing that. It's not like there's an attorney exception to the First Amendment, but there's a recognition that the rights are not the same when you're in the role of an advocate as when you are just a general citizen out trying to talk about issues of public import, or just honestly, frankly, whatever you want. So Gentile made very clear, like, here's the universe of the case law. Here's the general First Amendment principles. Here's why this is a problem. Here's why you get to treat lawyers a little bit specially, but here's why, attorneys don't give up their First Amendment rights by becoming lawyers. And so there's a very narrow language of a restriction that Gentile adopted, and that's reflected, excuse me, in many jurisdictions in their ethical rules. You can't make any extrajudicial statement intended for public dissemination that would tend to substantially prejudice the right to a fair trial, and like that's what you get. And so to see this order that is so clearly applying to people beyond that, like far beyond who the court has a legitimate interest in being able to restrict, and speech that's far broader than just, oh, this is going to make the trial unfair. Express outside of the court an opinion or make any comment for public dissemination as to the weight, value, or effect of any evidence as tending to establish the guilt or innocence of the defendant. You don't get to have a public opinion on whether he's innocent or guilty. Like this is extreme. People are allowed, especially given long-standing rule that you get to respond to accusations that are made against you in public. You have the right to defend yourself and to defend your reputation. So it was just mind-boggling to me, and it kind of continues to be to see these types of steps being taken with gag orders, and this particular one that's just so incredibly egregious, because it should be black letter law. It should be obvious to anybody who has made it onto the bench, who is in a position of adjudicating the rights and responsibilities of the government and the citizens and so forth. It's just a basic thing you should already know. I
mean, yes. And so what you had listed, basically nobody can have opinion. I mean, I can't believe that it was actually articulated in this state proposed 8 content-based limitations of any party, any attorney, agency. So are we talking, we're talking the jail, when he was booked? Are we talking, the court staff? Are we talking about the janitorial staff? Anything connected to the case, directly or indirectly? Did he have a hamburger on the way to court? Can the person at the Wendy's drive-thru talk about it? Any judicial employee or officer of the court, any public official now holding office, included but not limited to law enforcement. I mean, what? Any person, I mean, it's like, are you kidding me?
Yeah.
Seriously? How are you going to take care of this? And so when the justice is like, I'm just going to ask you, are we breaking the gag order here in the chamber? And the attorney rightfully responded, I don't know.
Yeah.
Yeah, we could be.
Yeah, and that was one of the challenges to it, was the vagueness of the order, and that's a common problem that you run into with restrictions on speech like this. This was part of the litigation also that we saw in the Koberger case. There was a gag order that was entered from day one. There, it was stipulated to by both of the parties, and so the media came in and litigated that, and they had to go through all kinds of different revisions because of these types of concerns. The initial gag orders were far more broad with who they applied to. They were far more broad with the type of speech that they restricted. And they, did often use these fairly ambiguous terms to describe, who or what was allowed and not allowed to be discussed. And so, even though it went through a series of revisions, that whole initial confusion always kind of stuck with the case, and people continue to have the idea that, like, with Koberger, that like witnesses, for example, are precluded. They're under the gag order. No, they weren't. They were in some of the initial ones, but that was revised later on because that would not be constitutional. Seemed to be pretty well understood by everybody at the time. So it's just, this is a lesson that courts seem to have to be learning over and over and over again. And it's such a fundamental civics question that it's alarming to me. It should not be recurring at all. Like this should be 101 for being a judge. Your role in facilitating public access to the courts should be like basic training. There should be like boot camp for judges, and the First Amendment rights of the public and the parties should be on there.
Well, and it's, the thing is that even, the justice that spoke before, the man said something to the effect of, what did he say? He asked a question at the beginning about, is this is the judge who signed this the one that issued bail?
Yeah, great question, Judge. Right, way to cut right to the chase.
I mean, it was like 1-2 punch, man. They came in loaded for bear, and I watched it, and then to watch the state try to make something called a what did he call it? Not strict scrutiny, but intermediate scrutiny. Oh. And they were like from the bench. I'm sure they had to withhold their cackle because they stopped him, and they're like, "What? That's very clearly." And they also had ruled on something very similar in 2020 in their own state Supreme Court. And it's just like, it is, I'm appalled at the way the state is, pick your state, where the way the government is so ill prepared and so conditioned to just get their way that they can literally phone it in. That dude who showed up got pantsed in that courtroom, and he should have, because he sounded like a nincompoop. And those justices had his number. It was just such a bizarre. But I think it's a combination of things. I think that some of the judges know exactly what they're doing. Judge Gull knew exactly what. I'm sorry, 100%. She did. When you put a press release, into your written order as problematic, you're establishing, you're like a you're like spraying your territory, you know, and it's like gross. That's not what you're here to do. You're here to like be the gatekeeper. But so that's one of the things that struck out to me. So I'm not willing to give much grace to any judge that would do something so bizarre and so sprawling. And I don't know enough about the Koberger case, frankly, to know how that, you know, rolled out. If that was sort of, you know, I don't know what the situation was comparatively.
It was stipulated originally by the parties. And I mean, I understand the thought process behind it because when he got arrested, it was just an absolute, I mean, worldwide feeding frenzy on him, on the case, on any type of information that they could get. And of course, the problem with a gag order is that it then just tends to perpetuate that kind of environment, because if, you know, you don't have access to good information, you'll settle for any information. And then, you know, it's easy to lower your standards for you know, what you think is newsworthy and what isn't in that kind of context. So I understand their thought process behind it. Like, yes, we don't want people tried in the press. And this opinion acknowledges the Shepard versus Maxwell case.
Give a page.
Sorry. Let me see.
Oh, I think I remember seeing. Hang on a second. Let me find it.
I'll see if I can. Yeah, Shepard versus Maxwell. They talk about it on page 10. And so this is the case. This is the case where the trial turned into an absolute circus, where the press was like, you know, interviewing witnesses right outside, you know, and they stepped off the trial, and just all this crazy stuff. Like, it had infiltrated the courtroom and gotten particularly bad, and the judge did nothing about it. And so this was the case that came down and said, look, courts have some responsibility to try to manage you know, crazy media and pretrial publicity and stuff like that. So it rose to a due process violation they found in Shepard versus Maxwell. So that's the countervailing consideration. And, you know, I can understand that. And I can also see, just kind of remembering back when Mr. Koberger was arrested, what that environment was like, you know, why that would have been a potential concern.
Sure.
Nevertheless, you know, number one, it is not up to the parties to decide. We, the public, have, you know, as much interest in being able to view the process as anybody else does. It's our government, it's our court, it's happening in our names. We have that First Amendment right to be able to inspect it. So it's a difficult balancing act, and that's why she's using these expressions like it's only a last case scenario. It must be as narrowly tailored as possible. It's only justified if it's actually going to be effective at remedying the harm that you've identified. So the standard is supposed to be, you know, so high that it almost can't be met. And it's only possibly going to be met by just the, you know, the smallest types of restrictions. But as we see in practice, that just that doesn't seem to be how it plays out.
And you know,
and I appreciate that judge so much calling out, you know, what we all know, the elephant in the room. What's your motive for not wanting public eyes on this? Oh, because you're the one that let him out. Thanks for making that clear. Like, to your point about, well, is it ignorance or is it deliberate? If somebody has an interest in not having eyes on it, then that's going to tend to lead to a much stronger inference that they knew exactly what they were doing.
Yeah, exactly. Absolutely. And you know, and this is one of the things that happened in the Delphi case too. I think the argument always is that the family, you know, the people were admonished in the courtroom, or, you know, about the gag order. And I think that even the families thought that pertained to them. And I know that it was like, you know, she really doesn't have any sort of, you know, she doesn't have jurisdiction over the families in this situation. So it's just, it's basically like, you know, what the market will bear, what you've been trained up to believe and do. And you'll just, yes, I'll take the judge's order, even if it's unconstitutional, or at least scraping that bar. we're like, yeah, sure. We'll just do whatever we're told. No, I'm sorry. Absolutely not. It didn't have to. So in Kohberger, help me understand. So it didn't have to go up to the Supreme Court level, because my fear in this Arkansas case, my God, are they going to try to argue this and appeal this to the Supreme Court? I mean, can you imagine this being a test balloon? That's what went up in my head. I'm like, oh God. Because are they making this argument because the state, one of the assistant AGs that argued this in Arkansas said something to the effect of, like the Nick McClellan-esque, and also actually it's the Brennanism that the state deserves a fair trial.
Oh yeah. Yeah.
And it's like,
Yeah.
what? We're the state, bitch.
Yeah.
It's like, sir, but so I'm a little bit in fear that they might be like, what do we want to do? Maybe not this case, but man. In Kohberger, did it not go to the Supreme Court in the state?
No, so in Kohberger, it did not go up, and that's largely because most of this litigation was happening with the first judge on the case, Judge. And
right.
I like Judge. I found him to be a reasonable man. He's obviously born for the job, right?
Yes.
So, but
there's a teleology there. Yes.
I found Judge to be very thoughtful, very open, not a prejudged kind of guy, really much at all. Certainly not compared to what we saw later with Judge Hippler. And so he was perfectly willing to entertain the arguments with the problems and to, craft it and to tweak it and stuff like that. And they did. And I think ultimately it turned into kind of a compromise sort of situation. He's a very skilled judge. For example, when they were arguing the case, one of the things that he has the talent of doing is to be able to talk people into a compromise, right? To negotiate from the bench. And so propose possible revisions. And, would that satisfy you? And they're being polite and they say, yes, well, now we're done. So as soon as I sign that order, your challenges has been resolved. You conceded this at oral argument. Right. So it was just, I think, a little bit more of a collaborative process at the end of the day, but that one that did rely heavily on that input from the press with their First Amendment advocacy.
Yeah, and the thing is too is that's what happens all too often is that unless you're a scrappy lawyer in from out of town covering an Indiana case and want to just haul off and do an original action, it's gonna be the news organizations and all their legal teams that are going to be making these fights. So that's why I have my own problem.
We notice when they distinctly don't do it in places like Indiana.
Well, yeah, but the thing is that they actually did in the very beginning. About the PCA, the Indiana coalition did. Now there was a consortium, but in that was before everything kicked off. And I mean, from a journalist perspective, so that was before, that was just access to information. It's like, what are you doing here? What happened later that I saw in Delphi it was more about how much dick swinging can I do here for my Dateline to get my,
Dateline. Oh yeah, those guys, those line cutting guys. Yeah, them.
Oh, right. That's right. Oh my God. But it's like when I saw that motion to intervene for public information, I'm like, you could have at least added, I don't know, take the temperature is there anything else that maybe anybody, because it was through the local affiliate and by proxy then, through NBC for Dateline. But there used to be sort of a concept in journalism that good journalism builds on good journalism. It's not who necessarily gets there first, right? Yeah. And that's television, right? So, but that's a whole other medium. Television is a whole other kettle of fish. But, more information was always good. And that's sort of the way that things rolled. But anyway, so a lot of times it does come down to these large media companies to have to try to wrest that away. I don't know. Again, I've got a love-hate relationship with that, with the
Yeah.
legacy. Yeah. But
Well, and that's one thing that Gull did in the case that was genius in a particularly malevolent kind of way, was that way that she did triangulate the press against the public. When it came to public access, she made them a privileged class. They got special access to the courtroom itself. They got special privilege to be able to view the exhibits and so forth. It's plainly unconstitutional, but the press has no incentive to challenge that, and so it falls to lowly me to try to make an issue out of that. And of course, the Supreme Court will act when they feel like it. And so if they want to wait until the trial is over and my issue is moot, that's what they're going to do. And it's unfortunate, but that's the system we have.
Yeah. Yeah. There's one part of this ruling that I loved that I just had to mention because of my love of weird UK or weird old English law. I don't know if people know what the Star Chamber is, but Justice Nicholas Brawny sure did in this concurrence in the Arkansas boy, and he comes in hot. And I'm here for some sweet Justice Brawny, whatever his name is, public official. And again, this is Arkansas in the Supreme Court ruling that smacked down the gag order. Public officials are not immune. God damn it, I love this. Public officials aren't immune from public criticism. Judges and prosecutors included. Hello, because the circuit court's gag order violates that principle. I join the majority's opinion, granting the writ and vacating that order. Oh, and then he's going to go on. But that sweeping order is only one part of a troubling pattern of attempts to shield this case from public view, beginning with I need my glasses, a non-public arraignment, right? Anybody, does this sound familiar to anybody? A non-public arraignment and ending with a handwritten note, right? We got some of those too in Delphi. Quote, the entire case, quote, from public view, sealing the entire case. We cannot allow that pattern to continue unchecked. So I'd invoke this court's superintending authority to reassign this matter to a new circuit court judge. See bloobity bloob, part X, Y, and Z. Anything less suggests that what's happened so far within the acceptable range of disagreement or administration, and it isn't. Begin with the gag order itself. On its face, that order targets a broad swath of people, barring them from expressing an opinion or making any comment about whether the evidence, yes, this is to your point, about guilt or innocence of the defendant. Worse, the order itself was sealed, raising serious concerns about selective enforcement. And it doesn't explain why there was such an extreme remedy was warranted. Instead, just declaring it would, quote, help ensure all parties get a fair trial. And then I wanted to come down here because he does go, the gag order in the context. Context, because it's very critical to the context here, is that the circuit court that issued the gag order here also granted Michael Foster's release on bail. It's that decision which the defendant's lawyers called a decision to release a, quote, predator who, quote, repeatedly violated the defendant's child on low bond that set off a chain of events that led to the fatal confrontation of the subject of this case. And it's that criticism, right? And I want people to think about how Gull was taken. I mean, she took that press release, quote unquote, from the defense team as a public jab. She took that personally. Yeah. And it's with that criticism that the state claimed and the circuit court effectively concluded justified gagging the defendant, his lawyers, and others. It raises serious concerns, enhances the appearance. Okay, wait, I wanted to get to Star Chamber. One moment, please. Because I pulled up some Star Chamber, some good 1600s law. No, I'm serious. It's great.
That's awesome.
Where is it?
It starts at the keep scrolling down.
Yep.
Scroll down. Oh, wait, no, sorry, up. I think it starts at the top of 26 and goes into, or no,
Oh
there it
yes,
is.
he
Yeah.
quotes some good old law lords too.
Yes.
The effort to shield these proceedings from public view also didn't begin with the gag order. It started with the circuit court's decision to arraign the defendant in a way away from public view. And even setting aside the potential constitutional concerns raised by a non-public arraignment, that decision highlights the order on review here isn't an isolated problem. And he cites to Press versus blah, blah, blah.
And Blackstone. Okay, Blackstone is the like 17th century commentary on the English common law, the history of the common law. This goes back to Old England and the principles that we adopted from that system.
Correct. I mean, most of the books that I have from my UK law stuff is, the Blackstone Press,
Yes.
right? I mean,
Yes.
there's a reason for that. This is an ancient law lord. So William Blackstone in his commentaries 132, confinement of a person by secretly hurrying him to jail where his sufferings are unknown or forgotten is a less public, a less striking, and therefore a more dangerous engine of arbitrary government, end quote. Thank you, Justice. Rather, it suggests a star chamber-like atmosphere. We cannot allow that to continue. Now, I would like to bring up a particularly fun star chamber. If people don't know what the Star Chamber was, it was a de facto hanging court in jolly old England in the 1600s, right? So
Yes.
where essentially, anything that ran afoul of what the king wanted, you walked in and you did not walk out typically. And here's one that I really love. I mean, they're all good ones. And I highly recommend.
Probably the most famous one is the trial of Sir Walter Raleigh. But I joke sometimes that our criminal legal system is a conviction production machine.
Yes.
And I do kind of mean that, but the Star Chamber is like the iconic example of that. Like it exists to, check a box to provide a veneer of legal justification to torture and put people to death.
Well, and exactly. And the thing is that, can you still hear me?
Yes.
Oh, okay. Cause my screen's going kind of wonky. But we're talking even trial by combat. So these are some of the things that happen. So one of my favorite passages here, is the part where he had already been punished for his writing. So essentially this person had besmirched, and libeled, the king, and, the prisoners were set in the pillory, their ears being cut off, and in the pursuance of their sentence, the 30th of June, 1637, he was confined to wherever castle in Wales. Now, this wasn't good enough. So the guy already had his ears chopped off, right, and been pilloried. So they hauled him back in before the tribunal again until he finally gave up the ghost and was like, and then they just dispatched him. So the thing is that this is what the Star Chamber was. And there's case after case and trial by combat after trial by combat.
The Star Chamber is the reason for a significant number of our bills of rights. It's the reason for the right to confrontation. It is the reason for the prohibition against ex post facto laws. It's the reason for the prohibition against bills of attainder. Because the Star Chamber is an arm of the king, and so it was basically there to keep the king's enemies in check. And so, if you're an enemy of the king, but we can't pin you on something specific, but your dad did something that we don't like.
Yes,
here we go, bill of attainder. We will attribute his misconduct to you and punish you for it. We will just go ahead and pass a law now and say that it applies to you. God, which one is that? The laws that are specifically addressed at one person. I forget. That's another one of the protections in the Bills of Right. Or we'll pass a law that didn't exist at the time, and we'll create a new crime that you committed last week, without even
right. Yes,
those are the types of things that they would do to produce the conviction, and that's what the founders were reacting to.
Oh, absolutely. And I mean,
believe that they'd be like, oh, the court has a recording of their proceeding that would be easily copyable and distributable to the entire public, but they'd have no right to it. I have a very hard time believing that the founders would buy into that.
Exactly. Exactly. There's something going on with my screen right now, and I can't see you for some reason. Hang on. Whoop.
I can't see you either, but I see myself.
Okay, hang on. Stay right there for 1 second, okay?
Okay.
Hopefully this doesn't go away. Hang on. I had this problem the other day.
For those of you interested, the trial of Sir Walter Raleigh was in 1603, and he was accused of treason. And it was a whole issue because he was primarily convicted on the basis of a coerced confession of an individual who was never brought into court, as well as affidavits signed by people that were never brought into court. So, he got convicted because why not? So I just gave a little lecture on Sir Walter Raleigh because why not?
I know. Well, okay. I had to restart. I think that the energy in the room just killed my computer. But yeah, so yes, there's that. But there's also, like, I think the last trial by combat was actually I can't remember which case that was, but that's the things that the Star Chamber did, right? So they're like, yeah, that's fine. We'll do trial by combat. And if you got, you walked straight from the, Star Chamber to the guillotine. And so when he not only cites to Blackstone, but also just reaches for the stars, if you will.
Yeah.
I was like, yes, sir. Correct. Absolutely. Because you're right. It drives at that very heart of the matter. And I don't think, listen, I honestly don't think it's an overreach either. And I think that, while the idea of sort of the gladiator, because that's kind of what the Star Chamber can conjure, right? From this kind of idea, I don't think that it's something to be, I think it's apt. And I think that my concern when I saw that this had gone to the Arkansas Supreme Court was that, holy crap, are they going to try to run this up the flagpole? I don't think they will in this case, just from a PR perspective per se. But I guarantee that there are people out there, prosecutors, state, that would love to do something like this, to preclude any sort of public information from getting out there. We've seen it too much. And it just, I don't know. It drives me.
Well, here's what's alarming about it. And here's why I think the Star Chamber is so particularly apt, is because what characterizes the Star Chamber is its impunity. The Star Chamber had no obligation to follow a rule of law. It got to operate entirely by fiat and do whatever it wanted. We here in the United States today, we at least ostensibly have as a principle that we operate under a rule of law. The rules are the same for everybody. Fairness requires that we all know what they are in advance and have an opportunity to be able to comply with them, have an opportunity to be able to defend ourselves and so forth. And that's because we have this principle of equality. We don't have a king that's superior to everybody else. We all stand on equal footing, so we're all entitled to the same treatment. When you see courts pulling stuff like this, these are courts acting with impunity. These are courts disregarding the rules, and because they want to. It suits their. In this particular case, it's a classic example of ruling by fiat rather than by applying the legal principle, and so that's why, is it going to go up? I seriously doubt it's going to go up for all the reasons that they've described. This is clear law. There's nothing for a higher court to be interested in this particular issue, because these issues have been settled for decades. There's nothing revolutionary about it. That's why it's so alarming to me to see a judge signing an order like this, having the best case scenario is just inexcusable ignorance of the First Amendment law that would obviously preclude an order like this from being signed. But the more, nefarious interpretation, of course, is that it's not ignorance at all. It literally is just fiat. They're going to do it because they can get away with it. And, occasionally maybe they'll get their wrist slapped, like this judge did here in Arkansas. But
I mean,
willing to take the risk. And so it really is. It's a court that is willing to act arbitrarily for its own interests without any kind of legal justification, simply because it has the power to do that. That is Star Chamber activity.
yes, absolutely. And absolutely. And the thing is that when that happens, the outcome can still be death, maybe not as immediate as a guillotine, but think about what we're kept from. We don't know what's going on with Mr. Allen, right?
Mm-hmm.
So
yeah,
was it a Star Chamber in Indiana? I'm gonna say maybe. I'm gonna say possibly, because people are walking on eggshells from everything that I heard coming out of there. The only person not walking on eggshells was Fran and Nick and his weird cadre of people, right? Because they were the state and they deserved a fair trial, much like Hank Brennan did.
Well,
and
let's talk about some of their interests in that as well, right?
Please do. Oh my God, yes.
Because
yes.
Okay, so this was the other part of your interview with Andy that got me raging was that going back to the safekeeping hearing and just remembering how that went down procedurally and the delays and all that stuff, extremely frustrating. But then the issue with Mr. Baston and the
my God.
He says the judge ordered it. The judge says I didn't do that, and we have, there's no concern about this at all. We just kind of forget that there's a conflict between these people. The defense doesn't get to bring his witness to court, and based on that, she makes findings that the defense is lying about his conditions, that he's in fact treated better than other inmates in the state of Indiana being held in Westville. There's an interest that the state has in covering up the treatment of Richard Allen, and particularly creating a legal record that they can rely on of the treatment of Richard Allen, because of the liability that they are potentially exposed to, based on the conditions in which he was held, the length of time in which he was held, and so forth. And so that's their interest, in shutting that down, and in the procedural improprieties, and who cares about things like I'm a witness now to what the sheriff is claiming over here as part of the process of what happened. Just disregard all that in the interest of we're going to cover up this issue to prevent the state from potentially being liable for it. And so that's extremely, concerning.
Well, and that's just, and the thing that people don't understand is that's just one thing.
Mm-hmm.
That's just one thing, right?
Mm-hmm.
And we're talking going back to Diener pulling the ripcord. Actually, we're going back to Ives pulling the ripcord, who was the previous county prosecutor, who was like, whoop, I'm out of here.
Yeah.
And then you bring in old Chuckle Bunny over here with the greased back hair and the porn stash, doing whatever the hell he's doing, all this, winking at the jurors and whatever. It's like, I just,
it's doing his Troy McClure act. He was doing his Troy McClure act.
It's just like, I mean, oh God, he's, he has bad hair. Anyway, but I think that is the nicest thing I can say about him. Is literally the nicest thing I can say about him. But so when covering up, and so having this, what is the state's interest in making sure that this information doesn't get out, including, like, to your point, the audio. Well, who's going to want to hear Fran sneering at people and snotting at people and being, who's going to want to hear her? And again, this is like sticks in my craw for well, a lot of things do, but talking about everybody got a barbecue over the weekend. Jury, I'm glad to hear that you had a great weekend with your families. I'm like, well, what the fuck are they doing in a goddamn, Motel 6 down the road with your staff, by the way. I
Yeah.
mean, I'm
Yeah.
just like, so people, the interest started with this crap shit investigation and the farce and the travesty that was the arrest. And that is their interest. The precluding Mr. Allen from his right to I mean, from the word go. The man had a lawyer.
Ignored, just ignored it.
Nick McClellan knew. Diener knew.
Mhm.
The jail knew.
Mhm.
How are we here?
Mhm.
Right? And that's the
Yeah.
chronic. So
And
so
that's
they
the
have-
star chamber. That's the star chamber issue right there. You know, when this very basic fundamental thing is being disregarded, I can't assume this is a mistake. This is too fundamental. Everybody knows this. There's no way you passed a bar exam not knowing that. So it's deliberate. And once it's deliberate, the question is why? What don't you want us to see? What don't you want? Why don't you want him to be able to defend himself? Why don't you want a fair fight? And then, you know, of course, read the transcripts and it becomes pretty obvious why they didn't want a fair fight. They couldn't win a fair fight.
They could not win a fair fight. And, you know, and again, yet they cloaked themselves in the, we care about these girls. And the one thing, you know, the other thing, there's a lot of things that piss me off. I've just said it, but making, I was so disgusted by them praising poor Liberty in death as the one that captured her own killer with the video. I think that, you know, I thought that was so disgusting and distasteful. And looking at the video now too, it's like, I don't get the sense that they were scared. Their narrative from the beginning was, it was just, it's egregious what they did to the mothers of these girls, in my opinion. I'm saying nothing about the other family members, but maybe to the mothers who actually gave birth to these two girls. Because they sold them a line of bullshit, starting with that. None of it makes any sense. And I think that's reprehensible. And that is by design on the state's part. We still don't know what happened at all. I'm left with we have no answers. We have this weird Hulu thing coming out that I'm thankfully going to be well out of the country for. But I don't know. I don't know where this goes now, that, especially since he's in Oklahoma. Now what?
Yeah. Yeah, I mean it's a mess. I mean you can see kind of the million ways that a case can go wrong, and it seems like so many of them have coalesced around Richard Allen. He's got, you know, the appeal is certainly going to move forward, and I've said many times, yeah, there's a ton of stuff I think that he has to work with. But you know, the saying "appeals are for losers," you know, exists for a reason. You never want to be in that position in the first place, and part of the issue that I have watching a trial like this too is kind of distinguishing what are the issues that are particular to this case, and then what are the issues that are just more systemic. Because the stuff that's more systemic, you can just kind of take it for granted that they're going to justify it because you don't want to change the system. And so things like, just routinely not funding defense experts. You know, you won't pay for a defense DNA expert. You're going to withhold like 60 grand, I think it was, from Mr. Rosie that hadn't been paid, you know, before trial. It makes him like desperate. He's got to be working on other stuff to try to pay the bills at his office. Those types of things can have an enormous effect on the ability to prepare for a trial and to do a good job and to be thorough and all of that. But they're systemic. And so they're extremely unlikely to be corrected because it would require a massive overhaul. And frankly, you know, paying for criminal investigations and you know, criminal justice, I'm going to use that term very mindfully now. It just it isn't a political priority a lot of the time.
Yeah, no, it's not. But you know, I no matter how much I hate people in the world, I do actually try to remain somewhat optimistic, because I do think that there is such, and maybe I'm making this up just to keep myself from running screaming into the void, but but it feels like there's more willingness, or if not an understanding of maybe some of the systemic issues that have been there since forever, with the criminal legal system, whether it's been disproportionately impacting communities of color, etc. But now you see it, more broadcast, if you will, more questioning and more concerns. Maybe people are becoming more open to the idea, like maybe defense is actually a thing that we should fund. Maybe actually using that COVID relief funding, instead of building that new prison, to fully fund your public defense, your public defenders in your state. All of these different things that really should be happening and can happen. And budgets are they're a moral document, right? In a lot of ways when it comes to the state. And so, I have grave concerns about.
Well, I agree. And to kind of take that full circle, I do think that people are, I mean, my impression, there's just a lot more interest in the system now, in crimes and in court cases, in historical cases, a lot of this stuff. There's a lot more interest in it now, I feel like, than 10, 20 years ago. Obviously, that's completely anecdotal. I'm sure there's probably studies out there about market research and stuff like that for like true crime and interest and things like that. But the point is that more eyes are on it, and I think there's a lot of reasons for that. DNA and the resulting innocence. Exonerations, I think, have played a big role because they've opened people's eyes to, hey, this is not just a hypothetical thing that could happen. Yes, it can, and it probably has happened that, for example, we've executed innocent people.
Yes. Yeah.
There's starting to be more focus on, and maybe this goes back to, I remember like Paradise Lost was the first example I can kind of remember of like a counter narrative on a criminal prosecution, and really questioning that narrative, and sort of the thought process, the storytelling that produced that conviction. But more eyes on it, especially more critical eyes on it, creates the incentive for those who benefit from the system perpetuating the way that it is to keep those eyes off of it. Don't see how the sausage is made. You're not going to like it. It's ugly. It doesn't bother them personally to be, running the gears at the slaughterhouse, but they don't want you seeing them doing that and judging them for it. So that's part of the impetus, I think, for some of the Star Chamber mentality that we see.
Absolutely. And to take that analogy one further, your sausage is full of lips and assholes, people. It well and truly is.
Yeah.
I mean, but yeah. So so here we are with but I think,
Heat up, fire up the grill, folks.
It's time for sequestration barbecue. Woo! Pew, pew, pew. I just can't. All right. Well, I think that I could go on, but
yeah, I could too. I could rant more.
I've done,
we didn't even talk about my grievance. I've been wanting to like vent for a while now.
Air it. What is it?
Delphi stuff. I'll just give you the sneak preview. The clerk's offices are funded by copies, and the copy fees for access to the law. The fact that law is
okay. Yes.
only available to people with money. Like it has to be bought, and that's so antithetical to the system of openness and so forth. The transcripts, the control over the transcripts, court reporters who will threaten people who republish transcripts and assert frivolous copyright claims and things like that. Like there's so much wrong with access to the courts, like on so many levels, and just this hostility to transparency and this, capitalist kind of side of justice,
So
make it something that's bought and sold. It's just infuriating.
But I want, so you sent me, and I actually read it, and I thought it was interesting about the copyright strikes from the clerks and one of the cases. And I didn't know this was a thing, but that, hey guys, guess what? You want to pay $5,000 for your transcripts? Well, wait until they get copyright struck. I had no idea clerks were doing this until you sent me this over.
Yeah, and so this has been like a long-standing thing. I've been aware of this like since as long as I've known about the courts, because I used to work in a court in California, and California is particularly notorious for this. And so, so one of the other things they'll do if the copyright stuff, somebody calls them out like that's bullshit. It's obviously bullshit, and it is. It's not an original work. It's
right.
Authorship or anything like that. But so California law is it's very specifically set up with anticipation that court reporters being able to charge for copies is part of how court reporters get paid. The state doesn't want to pay court reporters a living wage. And so it gives them this, the statutory framework for how, you get to charge X amount for the original and X amount for the copies and things like that. So then the court reporters will have this whole other avenue besides frivolous copyright where they can argue you're violating this law that sets up how you're supposed to pay for the copies to get a copy. And they can threaten you with like criminal prosecution and stuff, theft of services and things like that. So yeah, it's this wild control over access to the information that is supposed to belong to all of us in the courts, and it's in all of these different places and manifests in all of these different ways, and it's all really appalling and atrocious. And I just brought that up because of what a shit show it's been trying to get that documentation out of Delphi. And this is part of why. This is part of the game that gets played. Yeah, you can have the stuff, but you're gonna have to pay for it. So good luck with your fundraising. Teresa did an awesome job, by the way.
Yeah.
Neil.
Yeah.
If you don't have the money, you don't get the access to the courts.
And I called Jody and I asked her about this $1, this $5,000. And she said, I think I might have sent you this note that she told me that that was for the actual physical copies. And I said, well, Jody, I didn't say, well, Jody, I wanted to. I said, you understand that nobody wants thousands of pages.
Yes.
You understand that, right?
Yeah.
Do you have a computer machine? Do you have a computer machine?
The 2 seconds it takes for you to find the PDF in the file and click send, that's what people want. And that's what they're charging $5,000 for. And it's like that. It's like that all over the place with court copies and things like that as well. It takes no effort. It's already there in digital format. But they fund their office by charging you $5 to click send on the email. I was like, I couldn't believe it. And I said, and where's that? And I asked her about the money, and she's like, oh, that's been paid back. I'm like, great, sounds great, thanks, check that off my list. I'm just like, she was pissed too. Jody was pissed to be asked such questions. I'm like, bitch, you are a public servant. I mean, look, you're on the dole, in my opinion. You're on the Indiana. You're a public servant, man. Yeah, provide some service. Provide some service. That's your job. It's literally your job. And the arrogance with which they've refused, and just like I can see them laughing. I can absolutely visualize them laughing in Judge Gull's chambers about, the runaround that she gave this person that was trying to get the exhibits. Like it's just a massive arrogance on their part. It's how Jody managed to look. I got to bust this out. Hang on one second. It's how Jody pays for all of that time off. Yeah.
Because tell you what, that lady goes on some vacations. Bless her heart. But yeah, it's interesting because one of the court cases you sent me was literally about publishing a phone book and about how having to do with charging for transcripts. And I'm just like, that's from like 1966 case. And I'm like, somebody tried to copyright the phone book. It's factual matter. It's people's names. It's, and I'm obviously just glossing over what the case actually was, but I'm like, wow.
Have you ever looked into the case law about where West Publishing was suing the different courts, so West is commonly the official reporter for various state courts, meaning
God.
like they're the ones of record, and so they were claiming a copyright in their pagination system because basically they wanted a license fee anytime you cited the case. If you cited to the Pacific Reporter or the Northwest Reporter or any of those West publications, they wanted to charge you for it. And so the court put a kibosh on that. They basically said, no, that's just a product of your margins that you set. Like there's no, editorial component to that part of what you're doing. So they're not going to protect the pagination, but much of what West does is copyrighted. Their head notes, the syllabus, the organizations that they have for researching, the shepherdizing, like so many of the tools that lawyers have to use to be able to know what the law is, to be able to find it, to be able to compare it, to be able to see if it's still good law. These are editorial tools that have been produced by groups like Lexis and West. And that's all copyrighted. So, you can't print off the West case and republish it because, you'll get in trouble because their head notes are on it.
Right. Yeah. Okay. Now, exactly.
Anyway, just a little sideline. I thought you might be interested in that battle because my jaw dropped when I learned about that one. Can you imagine? The audacity? They wanted to be paid by citation around the entire United States.
No, what are you going to do? Are you going to then go back to the original case? And is there like some sort of escrow fund for that case that was originally? I mean, how do you even? I'm writing it down.
Yeah,
I'm writing it down.
I could probably find some of the citations for you. Send it your way.
So wait, are you talking like a Westlaw or a Lex? When you said Lexis, yeah. So you mean like services like that?
So when there's the legal publishers. Legal publishing is like this whole thing I could get into. It's a whole sideline. So state courts don't typically do their own publishing. Right. They just rely on folks like West, who does the regional reporters is what they're most known for. They also do the federal reporters for the federal system. And so they just, get copies of all of what are typically called advance sheets or, the slip opinions that courts do issue, and they compile them and publish them on a broader scale. And then, in the modern digital era, they've created all these search tools and things like that to, database it basically. So there is a lot that they do that I think is important and isn't, is and should be protected. But just the actual collection of the law, right, and presenting it does not seem to be one of those. But so because they have done this for hundreds of years and they've done it consistently, they are recognized as the official reporter in a number of different states. And so that means when I'm filing my brief in, for example, the Washington Supreme Court, the Washington Supreme Court has style guidelines and rules for how you cite to cases, and you have to cite to the official reporter. So if the official reporter is West, I have to cite to it. I can't cite to the slip opinion. It's the same law. It's still good law, but that's not what the rules let me do. So if I had to pay, West to cite to their official reporter every single time, who knows what it would cost me to be able to file a brief in a case.
Sweet Jesus, take the cheese wheel. I now have it. I mean, I can't Okay, tell me what you're up to these days. What are you working on? What's going on? What are you doing? Because I'm out of here. I'm leaving the country. But what are you?
I'm getting oriented, to be honest with you. Today was supposed to be the second day of jury selection in the Brian Koberger case, and of course that resolved by plea,
Yeah.
and it's over. It's done.
Yeah.
So that's not going to be happening. But that is kind of where my focus had been for like the last 2 years. I had just assumed these next 3 months were going to be, taken up by that. Now they're not. So I'm not actually entirely sure yet what I'm going to do. I am interested in this Aaron Spencer case, but it's not entirely clear to me. Are we going to be able to get good information about it at this point? Certainly the mood from the trial court is not really one of, magnanimous openness. So that I think remains to be seen, but that is coming up in the short term. I've been kind of flirting with maybe watching some of the Donna Adelson trial. I'm not too sure about that one either. But just kind of trying to keep an eye out for the next one that just gets my attention, that has an issue that I think is important. I try not to watch cases just because like, oh, it's a salacious case or something like that. I try to focus more on ones that I think have some kind of broader impact. So I don't always know them until, they come and hit me in the face. And at this point, I haven't necessarily been smacked. So keeping my eyes open. And when I find something, you guys will be the first to know.
And I think that the mods, through your link, obviously, and also to your Substack and your writing on your, you have your Substack in your, I think you have it in your.
I do. It's in my thing, and I will actually warn folks because my Substack has been kind of dormant for quite some time because when we were in like the depths of the Karen Reed trial, and that takes up 12 hours a day, I'm not doing a whole lot on the sides. But so I haven't done much on it for a while, but it is a good medium, I think, to do a little bit of more philosophical exploring and more kind of like one-off, something might catch my attention about a case, but it doesn't mean, I want to watch the entire case or watch the entire trial or something like that. So it's just a good way to, I think, look at things maybe a little bit more thematically as they catch my attention. So I've got all kinds of things that are in the burner right now. Nothing that's ready to hit publish on at the moment, but lots of different ideas. So do keep an eye on that if that's something you're interested in.
Well, do you have any interest in say UK cases like the Letby case? That's
less so, just because the legal system is so obscure to me. Like this was something I ran into with Depp versus Heard.
That's right. That's when we started talking about promissory estoppel.
Yes, exactly. We started talking and all these obscure issues and stuff. And so that had been one of the challenges with following that trial in the UK, the Depp versus NGN, was just because I have no idea what to predict. I have the same kind of issue with the Andrew Tate stuff. I'm actually quite interested in the Andrew Tate
interesting. Yes,
but I know nothing at all about Hungarian
civil
law.
And anything like that.
So I'm kind of a spectator, like anybody else. I'm not really in a position to be able to analyze it. So that's the challenge with foreign prosecutions.
Sure. No, I'm just happened to be on my way to study some EU law this next month. So maybe I can. Hungary is a whole other kettle of fish. It's a train. It's a mess.
Oh, I bet it is.
Yeah, it's awful. But so I'm just, oh my gosh, I haven't even looked at comment, you guys. I feel terrible. I feel yes, there she is. Can't. That is my favorite. I just can't. But so I'm gonna let you go. And then I can. Oh yeah, how's your bonsais?
Oh, they're great. We're in the really hot part of the summer, and so it always this is the challenging bit. People can get a little like crispy around the edges, and we're trying to keep everybody cool. But I live in an environment that's extremely hostile to life, and so it's just
me too.
Chase. I get to hide indoors with the air conditioning, you know, but the plants don't have that benefit. So
Oh. Well, I loved them. I loved having you on. My God, because hair, fire, Andrea, jeans, talking about our righteous indignation. But thank you so much for joining me, and I
Great.
hope to see what you get up to next. And I always love listening to your takes on everything. I really do. I think it's
Well,
great.
thank you.
I love
I
it.
really appreciate it. It's always a pleasure to come. I love our common interest in just what seems like it should not be such a big ask, you know, being able to get good information about court processes so that we can make sense out of what's happening with our system. And I as I said, I could rant about it for days. I feel like we've just barely kind of dipped our toes in, so let's do it again sometime.
Yes, absolutely. Yeah, and just come with your bulleted lists, everybody, because yeah, it's not going to be long before there's more. But thank you so much, Andrea. I really
My pleasure. We'll see you soon.
Okay, bye. Thank you, everybody. Hi. Sorry, so she's great, obviously. Gross. I feel terrible about saying the withdrawal thing. So I'm sorry. Oh my gosh. Wait a minute. Hang on. Thank you to some of your super chats. Thank you so much. I'm sorry. Listen, people who know me know that I can't pay attention to chat and also have a conversation. I'm just not good like that. But thank you. Lining up overnight can have its advantages. I ended up in line. Oh, shoot. I wish she could. Hopefully she's going to see this. So I'm going to copy. Thank you so much, Docket Decoder. I will. That's wonderful. Stuck talking to you. Oh, the tales, you could tell. I hope you're still around. Thank you so much. We'll make sure that she gets that note. And Dr. Vonda. My whole body's been on fire over Delphi. How many times did Vonda scream type conditioning and programming? Yes. And you listen. You're welcome. Thank you. And you gifted memberships. Thank you so much. And thank you. Hey, it's me. Thank you. Nick. Hey, buddy. Oh, yeah. You know what? Oh, Lord, coming in hot. All right. Well, you know what? Why does that not surprise me, Nick? Why does that not surprise me, everyone? Thank you so much for that. Well, I really want to thank all y'all for being here. Yeah, and look, maybe I can convince Andrea to do a recurring, like 2 Andreas, and it's going to have to be something like, because we're both Andreas, obviously. We're both Andrea Jeans. There has to be something there, like Andreants. I was trying to think of something like with Andrea and Rants, but whatever. You guys are way smarter than I am. Yeah, but maybe we'll have to think up something because, yeah. And I'm sorry again, because I was like, again, it's like squirrels and I can't watch the chat and everything, but, I'm just looking back through. I'm sorry I missed so many of your chats. I'm going to go, let's see. I'm seeing things about wigs. Yep. There's just, and I put, so in the comment, or I'm sorry, in the section about this video, I've linked to the Arkansas. It's really worthwhile to give that a read. And I would say even, watching the oral arguments, really good stuff. And It's so good. I put the links down there for that. I also put a link for the order from Witch's Fire. Witch's Fire. If you can jam just a whole bunch of old, literally 1500s law lords into your fiery, righteous smackdown in a Supreme Court argument, I'm here for it. 100%, 100%. Put that link in the description. I think there's a couple other links in there too. But love Andrea. Yep. So good. But thank you, everybody. I am going to be gone. And for a while. I'm going to be gone. And I don't think that I'm going to be checking in on the tubes, as I'm going to be very busy, doing some studying, and stuff. Maybe I will. I don't know. Yeah, I hope that, so unless something crazy happens, I might not see you all until end of August. Something crazy is going to happen though. I'm sure. And I'm sure that you all will let me know on the Twitter machine. I mean, I'm not going to Timbuktu where I'll be off, the interwebs, but I'm just not going to have time to do, marathon streams. Oh God. I don't know. Maybe I'll crank one off. Maybe we'll see. We'll see what happens. I don't know. But as always, I really appreciate people showing up. And I know that Andrea's a fave. And you guys are all my favorites. And yeah, I would love to hear in the comments below after this whole thing ends, what you think would woo Andrea, like a good name for a rant stream, you know, maybe bi-monthly, monthly, just to sort of unload. Yeah, leave it in the comments. And thank everybody for being here because, as you know, everybody sucks and I hate all of you.